Go. Hey guys, so in this video, I'll be discussing Title 2 or the crimes against the fundamental laws of the state. So it includes Articles 124 to 133. So let's begin. So the acts under Title 2 are made criminal because they both appease the Bill of Rights. So the rights under the Constitution, and the first of these is under Article 124, 125, and 126, which speaks of arbitrary detention. So there are three kinds of arbitrary detention. First is arbitrary detention by detaining a person without legal ground under Article 124. The second is arbitrary detention by failing to deliver the detained person to the proper judicial authorities within 12, 18, or 36 hours under Article 125. And arbitrary detention by delaying the release of the prisoners despite the judicial or executive order to do so under Article 126. So all of these we're going to discuss one by one. So first we go to arbitrary detention by detaining a person without legal grounds. So the elements are that the offender is a public officer or employee. So who is the offender in Article 124? So it says here, the offender is a public officer or employee. But not all public officers or employees can commit arbitrary detention. The public officer or employee can commit arbitrary detention are only those who have been vested with authority to effect arrest and detain a person or at least cause the detention of a person. So public officers who have been vested with authority to effect arrest and detain a person are what? Diba? They're the police officers. On the other hand, public officers vested with the authority to cause the detention of a person are members of the Congress. They can order the detention of a person who has been cited of contempt for failing to accurate their proof, or we have the judges, they can order the summary detention of persons cited in contempt of court. So the second element is that he detains a person. So the second element requires that the offender detains a person. So there is detention when the offended party is placed in incarceration. So when the offended party is placed behind bars or when the offended party is restrained of his person or liberty. So in order to amount to arbitrary detention, there must be an act of restraint on the person or liberty of the offended party. Absent that intent, absent the actual restraint on the person or liberty of the offended party, it can be any other crime but not arbitrary detention. So therefore, the Supreme Court said that intent to detain must be manifest. It must be evident. Absent that, it can be any other crime. So it can be serious illegal detention or slight illegal detention. So the third element is that the detention is without legal grounds. So the third element requires that the detention must be without legal grounds. So when is detention without legal grounds under Article 124? First is when the said offended party was arrested without a warrant of arrest. We learned this in our consti. So second is when the said offended party was arrested and his arrest and detention does not fall under any of the circumstances of a valid warrantless arrest. Third is when he is not suffering from violent insanity or any other ailment which requires compulsory confinement. All of these are not considered valid grounds for detention. So to reverse, what are the valid grounds for detention? So first, if the person does not receive and detained by virtue of a warrant of arrest. Second is if a person was arrested and detained under any of the circumstances for a valid warrantless arrest. We learned this in our kasi in flagrante delicto, ganyan. So third is if a person was suffering violent insanity or any illness which requires compulsory confinement. So yung kunwari, hindi naman kukunin na para kang tumakas sa jail or whatever. Pero kunwari, may COVID ka, di ba nga nire-require nila to be in quarantine? So these are the valid grounds for the arrest and detention of a person. So we have now a problem. What if A was driving his vehicle, entered the one-way street, and in violation of traffic rules was stopped by a police officer B? So si A, nakuha yung license niya and binigyan siya ng ticket ni B and was brought to the nearest police station and he was placed behind bars. He was detained. So 10 o'clock daw ng morning yon. Kasi B, yung arresting officer, umalis. And nung afternoon, bumalik si B sa police station tapos ni-release niya na si A nung dinetain niya yung nag-enter ng one-way streets, diba? So what crime is committed by B? So actually, B is liable for arbitrary detention. He is a public officer. Diba? Yung sinabi kanina, police officers are vested with the right. Tapos, did he detain the person? The detention was without legal ground. It is without legal ground because entering a one-way street and violating the traffic rules and regulation is not a ground for incarceration. It is not a ground for a person to be placed behind bars. So if a person committed a violation of traffic rules and regulation, like entering a one-way street or beating the red light, he should only be given a ticket. There should not even be a confiscation of the license. After that, he should be allowed to leave, but that is not ground for him to be placed under detention. Since the officer detained the person without any legal ground, he is liable for arbitrary detention. So, nakakatakot. Talaga ako pa naman, minsan nahuhuli ako sa habang nagdadrive. Anyway, so another problem is, what if X is suspected to be a snatcher and many complaints was filed against him? Si X daw. So one time when the police officers were conducting a patrol, they saw X who was perhaps waiting for a ride. When the police officers saw X, they immediately arrested X and brought him to the nearest police station. They told X that he is to be investigated, for he is said to be a cell phone snatcher. So he was brought to the investigation room. However, the investigation officer was not around, so the arresting officer told him that he needs to be investigated and that he can leave, but he may make sure to come back for the purposes of investigation. Otherwise, if he does not come back by the next time they see him, they will kill him. So because of that, si X umalis ng precinct but would immediately return. So yung mga police officers ba dito, are they liable for arbitrary detention? So the answer is no. The police officers are not liable for arbitrary detention. There is no intent to restrain or detain the person or the liberty of X, the offended party. So in order to amount to arbitrary detention, it is necessary that the intent of the public officer to restrain the person or liberty of the offended party, kailangan manifest yon. So in this case, hindi. So even if there is a threat on the part of the police officer, there is, however, no intent to detain X. So ano yung mga crime na nakomit nila if ever? Only grave threats because they threatened to kill X kung hindi siya bumalik. So we go now to the elements of Article 125. So like what I said a while ago, Article 125 is arbitrary detention by failing to deliver the detained person to the proper judicial authorities within 12, 18, or 36 hours. So the elements of the crime is that the offender here is a public officer or employee vested with authority to effect arrest and detain a person. The second element is that the offender has detained the person for some legal ground. So the second element requires that the offender arrests and detains a person for some legal ground. So what are the legal grounds referred to in Article 125? Article 125 is not the fact that the said arrest was made by virtue of a warrant of arrest. Because if the offended party was arrested by the public officer by virtue of a valid warrant of arrest, he does not have the obligation to deliver him to the proper judicial authorities. And the third element is that the offender fails to deliver the person arrested to the proper judicial authorities within 12, 18, or 36 hours. So the third element requires that the offender fails to deliver the person arrested to the proper judicial authorities within 12, 18, or 36 hours. So what are the valid instances in arresting a person? These refer to the circumstances of valid warrantless arrest. We already discussed this in the video for Constitutional Law 2 under Section 5, Rule 112 of the Rules of Court. So it requires that a peace officer or a private individual may even without a warrant arrest a person. So first, yung in flagrante delicto. So to just refresh your mind, that in his presence, the arresting officer, the person to be arrested is actually committing or is attempting to commit a crime. Second is hot pursuit arrest. So this is when a crime has in fact just been committed and the police officer has probable cause to believe, based on personal knowledge and facts and circumstances, that the person to be arrested is the one who committed the crime. Then the third one is when the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving final sentence or temporarily detained while his case is pending or has escaped while being transferred from one penal institution to another. So ito yung mga circumstances for a valid warrantless arrest. These are the circumstances referred to in the second element of Article 125. And like I said, on the third element naman, what do you mean by delivery? Delivery does not mean that you really have to deliver the physical body of the person arrested to the court. It means constructive delivery or legal delivery, meaning the filing of the appropriate case before the proper court. That is to deliver to the proper judicial authority. So filing of the case before the court, the law says that a public officer must deliver to the proper judicial authority. So judicial authority, what does it mean? The proper judicial authorities refers to courts of justices or judges of the courts that has the power to order the incarceration or detention of a person or his temporary restraint upon posting of appropriate complaint. So the fiscal does not belong to the proper judicial authority because he belongs to the executive branch. The fiscal is under the Department of Justice and not under the Supreme Court. The head of the fiscal is the Secretary de Lima, kung wari before. And yung president is not our Chief Justice right now. That's why a fiscal is not within the meaning of a judicial authority. So second, the fiscal may recommend the bail, but he does not have the power to fix the bail. So the law says that a public officer must deliver a person arrested to the proper judicial authority. So, paano mo determine yung 12 hours, 18 hours, and 36 hours? So, yung 12 hours, it's for crimes punishable by light felonies or light penalties or their equivalent. 18 hours for crimes punishable by correctional penalties or their equivalent. 36 hours for crimes punishable by afflictive or capital penalties or their equivalent. But now, actually, we have the anti-terror law. And under Section 29 of the anti-terror law, the police or law enforcement officer who has taken custody of the person suspected of terrorism may detain such person for a period of 14 days from the apprehension or arrest. And kung sinasuspect nila na terrorist to, and the period of detention may be extended by a maximum period of 10 days. So the Anti-Terrorism Act does not require the presentation of the person charged with or suspected of terrorism before a judge prior to the detention, but requires only that the apprehending law enforcement agent or officer notify the judge of the court nearest the place of apprehension of the time, date, and manner of arrest. So the location of the detained suspect and the physical and mental condition of the suspect. So there are a lot of issues that were raised regarding the whole anti-terror law, but specifically this Section 29. So some petitions were assailing the controversial warrantless arrest in Section 29 of the anti-terrorism law. So yung mga petition, it claimed that the law makes it possible for suspect to be arrested and re-arrested on an endless cycle since the contested Section 29 allows the Anti-Terror Council to authorize warrantless arrest and warrantless detentions for up to 24 days. And as such contend that on the 25th day, yung Anti-Terror Council may order the re-arrest of the designated individual or member of an organization that remains designated or prescribed as a terrorist. So there are a lot of issues that were raised with regard to Section 29, and until now, they've been debating on how this amounts to warrantless arrest. So what if a person has been arrested in flagrante delicto in possession of an unlicensed firearm? So possession of an unlicensed firearm is punished by a special penal law. So is the arresting officer required to deliver the accused to the proper judicial authorities? Does Article 125 even apply to special penal laws? So the answer here is yes, because the law says that or their equivalents, like penalties and their equivalent, correctional penalties and their equivalent. So actually what their equivalent means, that it may also apply to special penal laws. So the law says that or their equivalent, 12 hours for crime for light penalties. That means all their equivalent refers to their equivalent, even in cases of violation of special penal laws. Therefore, even if the crime committed or the crime for which the offender is being arrested is based on violation of special penal laws, the arresting officer has the obligation to deliver the person arrested to the proper judicial authorities in consonance with Article 125 of the Revised Penal Code. So what if the police officers caught X in the actual act of killing si Y? So they saw X and Y fighting and they saw X stab Y to death. So X is liable for homicide. They arrested X, and that was Saturday, 3 o'clock in the afternoon. Sunday, walang office. So the following day, Monday, happens to be declared a special non-working holiday. So the police officers were able to deliver X to the proper judicial officer only on Tuesday, 8 o'clock in the morning. So they were able to file the case in the fiscal's office for the purposes of proceedings. Then Tuesday, 8 o'clock in the morning, beyond the 36, that was already beyond the 36 hours, which was required by law. So are the police officers liable for arbitrary detention? So the answer here is no, because the police officers are not liable, since the Secretary of the Department of Justice has made a legal opinion that said 12, 18, and 36 hours refer to working hours. These refer to the time when the courts are open in order to receive the cases to be filed against them. So this does not include the crime wherein the courts are closed and they did not receive the complaint or information to be filed against the accused. So we go now to Article 126, or arbitrary detention, by delaying the release of prisoners despite the prisoner's judicial or executive order na napakawalan na sila. So what are the elements here? First is that the offender still is a public officer or employee. The second one is that there is judicial or executive order for the release of the prisoner or detention prisoner, or that there is a proceeding upon a petition for the liberation of such person. Third is that the offender, without good or valid reason, delays the service of the notice of such order to the prisoner or the performance of such judicial or executive order for the release of the prisoner or the proceeding upon the petition for the release of the prisoner. So note that what is punishable is the delay without valid reason. The delay of the release of the prisoner despite the judicial executive order to do so. So example of judicial order for the release of the prisoner, let's say that a person has been charged in court and the public prosecutor failed to present any evidence for consecutive times and no witness has been ever presented. So the judge will dismiss the case and order the release of the accused. So this is an example of a judicial order for the release of the prisoner. So, or let's say a judge acquitted the accused, then he will order the release of the said accused from jail. So how about an example of an executive order? So a person was arrested and placed behind bars, and the proceeding was filed before the fiscal's office. So the fiscal ordered the release of the prisoner. This is an example of executive order, as we said a while ago, since yung fiscal, they are under the executive branch. So what if X was charged with two crimes? So first is illegal sale of dangerous drugs and then the second one is illegal possession of the drugs. So dalawang crimes was filed against him. The illegal possession of dangerous drugs was filed before, let's say, the regional trial court branch 1, and on the other hand, the illegal sale was filed before the regional trial court branch 7. So in the case of the illegal possession of dangerous drugs, which was filed in RTC branch 1, no witness were ever presented, and so the judge, like our example a while ago, dismissed the case and ordered that X should be released. However, for the illegal sale rather of the dangerous drugs under branch that was filed under branch 7, ongoing pa yung case. So the jail warden receives the order coming from the judge in RTC branch 1 that X should be released. So the jail warden did not comply. So yung jail warden ba is liable under Article 126? So the answer here is no. Since the jail warden is not liable, since may isa pang case na pending against X, therefore, it is incumbent upon him not to compel the judge of branch 1 since there is another case in branch 7 which is still ongoing. So what the law punishes is the delay without valid reason for the release of the prisoner. And here, there is a valid reason since may isa pang case ongoing on branch 7. So we go now to Article 127, or expulsion. So expulsion is committed by public officers or employees who shall expel any person from the Philippines or who compels him to change his residence without any lawful authority to do so. Again, the offender is a public officer or employee who acts either by expelling a person from the Philippines or by compelling a person to change his residence. So what the law prohibits is that if the public officer or employee expels him from the Philippines or compels him to change his residence without lawful authority to do so, because there are persons who have been authorized by the law to deport a person from the Philippines or to compel a person to change his residence. Like, for example, the President of the Philippines, he has the power to deport or expel a person from the Philippines. Another example is a foreigner who is known to be a persona non grata. the president may order his deportation to his home. So the courts, on the other hand, have the power to compel a person to change his place of residence. Let's say the offender is a concubine, and the penalty to be imposed to a concubine, as we learned, is destierro. So therefore, the concubine is prohibited from entering a particular place based on the judgment of the court. Now, the prohibited place, sorry, from which she is prohibited from entering is the place where she lives. She cannot enter the said place. Therefore, the court is empowered to compel her to change her place of residence because that was the penalty that was given to her. So now we go to violation of domicile, or Articles 128, 129, or 130. So a public officer or employee entered into a dwelling of another which is not armed with a search warrant. The different prohibited acts constituting violation of domicile is one, by entering a dwelling against the will of the owner. Second, by searching papers or other effects found without the consent of the previous of such owner, and by refusing to leave the premises after having surreptitiously entered the dwelling, being discovered and asked to leave. He refuses to leave. So the elements of Article 128, or violation of domicile, is first, again, the offender is a public officer or employee. He must be a public officer or employee acting under color of authority. So a public officer or employee is said to be acting under color of authority if he has been vested with the authority to implement a search warrant. But when he entered in the said dwelling, he is not armed with a search warrant. Therefore, he was acting under color of authority, even if he is a public officer or employee, but he did not act under color of authority. He is liable only not for violation of domicile, but for qualified trespass or trespass to dwelling, because the public officer or employee is acting under his private capacity. So the second element is he was not authorized by a judicial order to enter the dwelling and or make a search therein for papers or other effects. So the second element requires that entering upon the dwelling of another, which is not authorized by a judicial order. The judicial order refers to a search warrant. This was also discussed in another constitutional law 2 video. Yung mga valid search warrant, there's no search warrant. So the third element naman is he either enters the dwelling of another against the will of the latter, or searching for papers or other effects found therein without the consent of the owner, or after having surreptitiously entered the dwelling, being discovered and asked to leave, he refuses to leave. So the third element provides for different modes of violation of domicile. So these three modes are separate and distinct from each other. So wag mong hanapin sila in a problem. So the violation of one of them will already bring about the crime in Article 128. So yung first that is contemplated in the third element is by entering any dwelling against the will of the owner. So there must be a prohibition, an imposition from entering. It can either be implied or expressed, opposition from entering. So yun na nga, yung parang sinabi natin sa trespass before. No one can enter my house. So the express prohibition is when the owner is inside the house and the officer knocks on the doors, and upon seeing the officer, he closes the door. So yung mga no entry, nakalock, ganyan. Then another contemplated in the third element is by searching papers or other effects found therein without the previous consent of the owner. So the consent of the owner matters. So even if the public officer or employee is allowed inside, the fact that he is not allowed inside does not mean that he is allowed to conduct the search. So he must ask first for the previous consent of the owner before proceeding with the search. Without the previous consent of the owner to conduct the search, any search would be a violation of domicile. And third, by refusing to leave the premises, ito yung third element, kanina pala second element, after having surreptitiously entered the dwelling. It is his refusal to leave the premises that will bring about the violation of domicile, not the surreptitiously entering, but it is required that entering must be done surreptitiously. So surreptitious entering means entering the dwelling secretly, candidly. So therefore, it is important that he must refuse to leave after being discovered and ask to leave in order to amount to violation of domicile. So mere surreptitious entering will not bring about the violation of Article 128. So an illustration for this is, the door of the house was closed, but it was not locked. A police officer without a search warrant opened the door. Realizing it was not locked, entered the house and went up to the sala intending to conduct the search. Before he could conduct before he could conduct the search, the owner of the house saw him and told him to leave, and he left. So is he liable for violation of domicile? So the answer is yes, he is liable for violation of domicile, even if he left the said place upon being to told to do it. He is already liable because his entry was against the will of the owner. The door was closed, although it was not locked. Therefore, there was an implied opposition, an implied prohibition from entering. When he entered without a search warrant, intending to conduct a search, he is already in violation of domicile. So what if the police officer knocked on the door kasi nakalock? It's si X, inopen niya yung door. And upon seeing the public officers, X allowed them to enter. So sabi ng police officers, they were looking for a stolen car. So magse-search daw sila. Then X said, no, you can't search inside my house. Then the police officers agreed and left. So are they liable for Article 128? So they are not liable because it is not entry against the will. They did not conduct the search. The entry was not done surreptitiously. It does not fall under any of the elements we just mentioned a while ago. So therefore, they are not liable. So in the same problem, when they told the owner that they were conducting a search for a stolen car, so sabi nga, you cannot conduct a search, walang ninakaw sa loob ng house ko. But the police, let's say they still search the house. So this time, they are liable for violation of domicile because they made the search without the previous consent of the owner under the second act under 128. So now we go to Article 129. So search warrants maliciously obtained and abuse in the service of those legally obtained. So what are the prohibited acts under this article? So it's violation of domicile, search warrants maliciously obtained and abusing the service of those legally obtained is committed through the following: by procuring a search warrant without just cause. So when a public officer or employee conducts a search and the search warrant was illegally procured search warrant, it was procured without just cause. So ano ba yung search warrant? So to refresh your mind, it is an order in writing issued in the name of the Philippines and people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and to bring to the court the particular things to be seized. So before a search warrant may be issued, the following are the requisite. It is required that it is for one specific purpose. There must be probable cause. The said probable cause was determined by the issuing judge personally through searching questions and answers in writing under oath or affirmation as a testimony given by the applicant of the said search warrant, any witnesses he may produce. Fourth is the applicant of the search warrant and his witnesses must testify only as to the facts personally known to them. The said search warrant must specifically state that the place to be searched and the place to be seized. If any of these requisites is wanting, then the said search warrant is illegally procured. So it is procured without just cause. A search conducted by virtue of a search warrant illegally procured without just cause is akin to a search without a search warrant. So the second element naman is by exceeding his authority or by using unnecessary severity in executing a search warrant legally procured. So ito naman legally procured. So a search warrant is valid only from a period of 10 days from the date of its issuance appearing on the search warrant. So what if a search warrant was issued against A? The place to be searched is located at, let's say, 10 Jupiter Street. And so the police went there. The house was owned by A. But the house was owned not by A pala, but by B. So they looked for the house of A. And the house of A was 5 Jupiter Street. They presented a search warrant to A. And A said, you cannot conduct a search warrant in my house. The address is in the search warrant is 10 Jupiter Street. And my address is 5 Jupiter Street. So nevertheless, the police officers conducted the search and they found illegal items inside the house. Are the police officers in violation of domicile? So are the confiscated admissible evidence against the owner? So the officers are liable for the violation of domicile when they conducted the said search on a house that has a different address from that in the search warrant. They exceeded their authority in the said search warrant. The search warrant is so worded expressly as to the thing or place to be searched. The police officer cannot exercise discretion. They must follow what is stated in the search warrant. The moment they did not follow what is stated in the search warrant, then they exceeded their authority. So in that case, when there is variance between what is stated in the search warrant and the actual facts of the case to be searched, they have to go back to the judge that issued the search warrant and they have to ask or move for the amendment of the said search warrant. So yan yung example kanina. So we now go to the elements of Article 130, or searching domicile without witness. So the prohibited act here is by conducting a search in the absence of the owner of the house or any member of his family or two witnesses residing in the same locality. So the elements of the crime is of an offender is a public officer or employee. So the second is he is armed with a search warrant legally procured. Third is he searches the domicile, papers, or other belongings of a person. Fourth is that the owner or any member of his family or two witnesses residing in the same locality are not present. So an illustration would be, what if under Article 130, for first example first, violation of domicile is committed when a search warrant was conducted in the absence of the owner of the house or any of its member or two witnesses residing in the same locality. So a search warrant was issued against X, and the police officer went to the house of X. So they showed the search warrant to X, and they were allowed inside to conduct the search. In conducting the search was witnessed by two barangay tanods who came with them. So who arrived with them in the house of X. So in the conduct of the search, they told the owner of the house, X, that his wife and his two children to remain in the sala while they conduct the search inside the bedroom of X. So in conducting the search of the bedroom of X, the search was witnessed by the two barangay tanods, and they found two plastic sachets of shabu underneath the pillow inside the bedroom of X. Are the police officers liable for violation of domicile under Article 130? Are the evidence seized admissible against the owner? So the police are liable for violation of domicile under Article 130. Article 130 provides for a hierarchy of witnesses who must be present in the conduct of the search. So the law says that it must be witnessed by the owner of the house. It is only in the absence of the owner of the house that it must be witnessed by any member of his family. It is only in the absence of the owner of the house or any member of his family that there must be two witnesses residing from the same locality. So in the problem given, the owner of the house was there, the members of his family were there, but they were not allowed to witness the said search. Therefore, the said search was conducted in violation of Article 130, and any evidence confiscated will be inadmissible against the owner of the house for being fruits of a poisonous tree under the exclusionary rule in political law. We also learned this in Constitution. So we go now to Article 131, or prohibition, interruption, and dissolution of peaceful meetings. So this is committed by a public officer or employee who commits any of the following acts. First is by prohibiting or interrupting, dissolving without any legal ground the holding of a peaceful meeting or by dissolving the same. Second is by hindering any person from joining any lawful association or from attending any of its meetings. Third is by prohibiting or hindering any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. For the crime to arise, it is necessary that the meeting that was prevented, interrupted, or dissolved must be a peaceful meeting, and it must be for any lawful purpose. If the meeting is not for a peaceful meeting, or if the meeting is not for lawful purpose, a public officer or employee has all the rights to prevent, interrupt, or dissolve the said meeting. So this is in the exercise of freedom of speech, freedom of expression, and freedom of assembly. However, these three freedoms are not absolute. The Supreme Court has enjoined the power of the state to regulate the meetings through permits. So before any of these peaceful meetings for a lawful purpose may be held in a public place, there must be a permit coming from the local authority of the place, so like the mayor. So the permit is only to regulate the said meeting and not to prohibit it. Regulate as to the time, place, and to the date so that the public would not be in inconvenience. So we go now to Article 132, or the interruption of religious worship. So the elements are, this is committed by an offender who is again a public officer or employee. Then there is a religious ceremony or manifestations of any religion are about to take place or are going on. And third is that the offender prevents or disturbs the said religious worship or religious ceremony. So if the offender makes use of violence or threats in committing the crime, such use of violence or threat would not constitute a separate and distinct charge. Rather, it is considered an aggravating or qualifying circumstance, which would mean an imposition of a higher penalty. So, for example, there was a barrio fiesta and the priest is about to celebrate the mass. So here comes X and he went to the priest, and then the priest did not mind him. So X intentionally pointed the gun to the head priest and said, "I will kill you if you celebrate the mass." So the priest did not celebrate the mass, and all of the faithful went out of the church. They got scared. So what crime is committed by X? So X is liable for interruption of religious worship under Article 132. So what about the fact that he pointed the gun to the priest? Is it grave threats? So hindi siya grave threats. The fact that threats were employed in the commission of the crime would only mean the penalty will be imposed in its maximum period. It would be considered an aggravating circumstance in committing the crime of interruption of religious worship, but it will not bring about a separate and distinct charge of grave threats or even underlying threats. And we go now to the last article, or Article 133, offending the religious feelings. So we have three elements. The first element is committed by a public officer or employee or a private individual. The first element provides for the offender. So the offender may be a public officer or employee or a private individual. This is the only crime under Title 2 where the offender can be a private individual. From Article 124 to Article 132, under Title 2, the offender can only be a public officer or employee. The exception is Article 133, offending the religious feelings, wherein the officer can either be a public officer or employee or a private individual. The reason is whoever may be the offender, a public officer or employee or a private individual, there will be the same offense made on the feelings of the faithful. So the second element is that the said offender performs acts in a place devoted to religious worship or during the celebration of any religious ceremony. So the second element requires that the offender performs acts notoriously offensive to the feelings of the faithful. Then the third element is that the acts must be notoriously offensive to the feelings of the faithful. So acts notoriously offensive to the feelings of the faithful are those acts directed against their religious dogma, ritual, faith of the religion, or mocks, ridicule, or scoffs of the said dogma, ritual, faith, or attempts to damage the object of veneration of a certain religion. So the law says notoriously offensive. So according to the book of Reyes, it means that it is offensive to all kinds of religion. If the same thing would be done to any religion, they will also be offended. So the third element requires that the said acts notoriously offensive to the feelings of the faithful can be committed only in a place devoted to religious worship or during the celebration of any religious ceremony. So the law uses the word or. Therefore, if the act is done in a place devoted to religious worship, it is not necessary that there be a religious ceremony ongoing, because it can either be with or without a religious ceremony for as long as the place is devoted for religious worship. So to illustrate, so what if X, a private individual, entered the Catholic Church? After that, the tabernacle was opened and he took out the chalice, and inside the chalice was the host which was being received by Catholics during communion. So he poured the host in the floor. He poured the host in the floor and he destroyed them. So he spit on them and stepped on them. So is he liable for violation of Article 133? So the answer is yes. The act he performed is notoriously offensive against the feelings of the Catholics. If the same act is to be done, the object of veneration of the Buddhists, or if the same act is to be done from the object of the veneration of the Muslims, they will also be offended. Therefore, it is notoriously offensive to the feelings of the faithful, because even if it is applied to other religions, they would be offended. So what is done? It is done in a place devoted to religious worship, the church. So another problem would be, so what if inside the PICC there was an art exhibit ongoing and one artist has this picture of Jesus Christ, and the picture of Jesus Christ, he puts a representation of, for example, a penis on his face. So is that said artist liable under Article 133, offending the religious feelings? So here, no, because he cannot be liable for offending religious feelings under Article 133, because the PICC is not a place devoted for religious worship, and the art exhibit is not a celebration of a religious ceremony. Therefore, since the last element is not present, even if it is offensive to the religious feelings of the Catholics, it cannot be held liable under Article 133 for the absence of the third element. Okay, good. So that was it for Title 2, or Crimes Against the Fundamental Laws of the State. Thank you for listening. And I'll be uploading the next few titles if I get the time. I hope this helps your review in criminal law too. Thank you.